So Dennis leads one of New Zealand's fastest growing trade unions, First Union, and they have members across retail, finance, transport, logistics, manufacturing, and also ambulance. So he's a well-known activist and union leader who has helped lead campaigns to improve the lives of migrant workers. And he actually founded the network of migrant workers within First Union. Lastly, on Dennis, he was born in the Philippines, and actually he became the first Asian New Zealander to lead a major trade union when he was appointed to his current role in 2017. So thank you, Dennis. I'll just close down my camera now, and I'll hand over to you. Thank you.
Thank you, Yasmin, and again, thank you everyone for joining us today. Um, well, I think what I will do is that I'm going to give you some presentation about recent slides. I'm just going to be discussing about burning questions that most um, migrant workers have been asking us for the last few weeks. So there are four main areas of discussion, and that will be interested um, for you to hear. The first one is actually the wage subsidy. I'm sure you have a lot of questions around that. The second one, I don't know if ever you are familiar with the essential leave. That is actually one of those announcements of the ministers, especially our prime minister. And the third one, we expect that because of the forecast on recession and the unemployment that would actually reach around 10% and probably around 20%. So we expect that there will be redundancy. And the fourth one that we are campaigning at the moment is actually the emergency benefit for migrant workers. All right. Now, okay. So, in terms of the discussion, we receive a lot of questions regarding wage subsidy, especially that we are moving to level three by next week. And I think the question is that are employers required to pay the employee 100% post lockdown? So, meaning once we actually reach level three and having leading to level two. Because we have to remember that the wage subsidy is actually effective for 3 months. So those employers who receive that must actually use that wage subsidy. Now, before I answer that question, we have to start from the previous announcement of the government that the wage subsidy is actually for those who are currently employed by those companies. And if ever you are subject to lockdown and there's no work for you, the guidelines provided by the government through the Ministry of Social Development and guidelines coming from the Ministry of Business Innovation and Employment is that the employer must endeavor to pay the 80%. Okay, if ever they cannot pay the 80% of the wages for the normal hours of their employees, then they can simply pass on the 585 if ever they're working more than 20 hours a week, or $350 if ever they're working less. Okay, so just to point out in that area, if the employer actually failed to consult you about the intention whether to pay you 80% or pass on the 585, so meaning there's no consultation, there's also a risk for employers that they're exposing themselves to future litigation because they must actually consult and must be transparent to their employees before they actually provide those subsidy, or in whatever capacity they can actually provide 80% or simply pass on the 585. Okay, now there will be a lot of questions around that, and the legal experts are still debating that, but that's what is happening at the moment. So I think the clarity of that, whether that is actually the correct thing to do, the realization is after the lockdown, because I think there will be some discussions among the employment legal experts. But right now, it's either 80% or simply passing on the 585. The next question is that, which I also received on my Facebook Messenger, is that come Tuesday, and that's going to be the start of level three. So if ever you belong to construction, manufacturing, and forestry, then you'll be able to start working. But from my understanding, it's not going to be as simple. Anyway, I don't know at what stage I lost my discussion, but I'm just saying that moving to level 3, as long as the workers are required to work and allowed to work, they should be actually paid based on the 100%, except for this week, coming week, because remember, we're going to be starting on Tuesday. So even if ever someone asks me a question that how about the ANZAC day, the point is that it's not otherwise a working day for you. So you're just going to be paid from Tuesday to Friday. But the following week, you should be receiving the wages. So the wage subsidy is just going to be a money that employer will be using in order to top up your wages so they can actually pay you 100%. Now, the second point there is that what if ever we're still actually not allowed to work on level 3, then that's going to be a challenge, because meaning the employers may choose either to pay you 80% or passed on the wage subsidy. And we're hoping that the cabinet is actually having a meeting at the moment, and they will also provide further clarity about how the employer should be using the wage subsidy on level 3, and if ever we move actually to level 2 by the month of May. Okay. The next one is, can an eligible employer not apply for a wage subsidy as not to pay the workers or force them to take annual leave or sick leave? Well, there are two things there. One is that the Ministry of Social Development provided a clear guideline that employers should not be using annual leave if ever they are eligible and applied for wage subsidy. Okay. And that's going to be part of the investigation of MSD if ever they found out that some employers are actually using annual leave while they applied and received the wage subsidy. The second element there is this. There's such thing as Holidays Act. So meaning employer cannot arbitrarily force you to use your annual leave without a proper consultation. Remember, annual leave must be by mutual agreement. And if ever both parties cannot reach a mutual agreement, the next step for the employer is find a way how they can actually use the annual leave by giving them 14 days notice. But even that second step still be under question, because again, if the employer is actually eligible to wage subsidy but still forcing the employees to use that, then a migrant worker or any worker can actually file a personal grievance for unjustified disadvantage, and they can actually request the employer for the annual leave restoration after the lockdown. Now, the third one, there is also a burning question, and this is being debated online in the last 3 weeks. For example, can an employer exclude workers who are stuck in overseas, from its wage subsidy application? We received this question because we actually understand that there are many migrant workers in India, China, and Philippines who are still employed by the company, and the company one is actually non-essential business. So meaning their company is not also operating. But however, when they've been asked whether they will be covered by the wage subsidy, then the answer of the employers, they cannot actually include them because they are not in New Zealand. And the advice they are receiving from employment lawyers, basically, if ever you are not ready, willing, and able to work, then you should not be covered by the wage subsidy. From the get-go, First Union argued that that is not the case, because the point is that if ever employers are using the argument of ready, willing, and able, meaning how can you use that argument if ever the business of that employer is not also operating because they are also under the lockdown rule? So therefore, they cannot actually apply that in one side because it must be applied both ways. So it doesn't matter where you are, whether you are in India, China, and Philippines, as long as you are employed by the company, and even if ever you are in front of the work site, if the business is not operating and they're still subject to lockdown, those employees who are still employed by the company are eligible to wage subsidy. Now, the question is that what if the employers did not include their name? Now, those employees actually must write a letter to their employers saying that they are eligible. And what they can do now, because I'm sure a lot of them will be hesitant to simply ask that question, but there is now a letter coming from the Ministry of Foreign Affairs and Trade under Winston Peters. And there's also an article published by RNZ regarding that. And because of that, we've been saying to the public that we've been actually vindicated about our interpretation of the law. So for those of you who are in that situation, you may actually contact us. We can provide you that information, because it's very important that those workers, regardless of their immigration status, as long as they are employed by the company, to contact their employers, and there's ability for employers to continue to apply for wage subsidy, and they can actually use that information that came from MFAT and MBIE. All right. Now, what if ever they are essential business and their employees are actually in overseas? Look, if ever there are companies like Pack and Save, for example, or Countdown, meaning they are not eligible for wage subsidy because they are fully operating as a business. But if there are companies who are just doing essential business online, like the warehouse, and they are actually eligible for example, for wage subsidy, then they can actually apply for wage subsidy even if their workers are still stuck overseas or living overseas. All right, so those are the two things that we have to clarify. Okay, now there is also a question to ask, and even employers are asking the same question. They say that, so what happened to the leftover money from the wage subsidy? So meaning this is the wage subsidy received by the employer. I think there's a question is that, are we actually giving it back to the Ministry of Social Development if ever it was actually in use? Look, there is no clear guidelines from the government, but we had the opportunity to ask question to Grant Robertson, Ministry of for Finance, and the explanation given to us is that if there is a leftover from the wage subsidy, it can be used by employers as part of the pool money. So meaning that the rule of the time, according to MSD and Minister of Social Development and Grant Robertson, is that they should not deposit that money to a separate account. They should just simply use that money exclusive to wages. So meaning if there are some employees who've been missed out from the wage subsidy, like the example for employees who are stuck overseas, they can actually use that pool money in order to pay them, to make sure that no one will be disadvantaged while we are still in lockdown and while you are still using that for the 3-month time period. Okay, so that's how the pool money actually should be used. Now, if ever there are some consideration, for example, they're still struggling to pay some amount of money for casual workers and they've been missed out, the employer can also use that pool money for that purpose. Okay, now many of those migrants who also contacted us, they've been saying that they are working for essential businesses. However, there is a guideline from the Ministry of Health that if you are at higher risk, so meaning there are a combination of that, you are living with someone who's actually over 70 years old or immune compromised, or you were actually tested positive, or one of your family members were tested positive of coronavirus, then there is a guideline released by the Ministry of Health that you can actually apply for essential leave, even if ever you are working for essential business. But there is a problem there that we already raised to the minister, especially to the cabinet, because aside from that guideline, whether you will qualify based on the health guideline, there is also another paragraph in the guideline that even though you're essential business, you must also have either experienced a minimum 30% decline in actual or predicted revenue. And because of this wording in that guideline, many companies now are struggling to avail that essential service leave for their employees. And because there is a guideline about this, uh, there are only few employers who were able to apply and avail the essential leave. Now, our concern is one, the guideline is actually vague, so which we raised that last week. And my understanding is that it's now being discussed and debated at the cabinet level. And the second thing that we are asking from the government is that whether they will be issuing a guideline once we move to level 3 by next week, because I think it's very important, because otherwise many employees out there, including migrant workers, will be out of pocket because they're scared actually to work because of the vulnerability of their household members, and they're also actually exposed to higher risk. So that's a question that we are asking, and hopefully there will be some clarification by next week. Okay. Now, I'm sure there are many questions about redundancy, and we are estimating that the impact of redundancy would be actually in the hospitality business and a couple of companies who are actually exposed to export and import business trade, and because of their supply chain. So I think it's very important that any employer under the Section 103A of the Employment Relations Act must be acting in good faith. So part of that good faith provision is that if there is a redundancy in the company, there should be a genuine consultation. So meaning the company must explain now the business situation by providing them some information about the status of the company post-lockdown. And I think the second one that the company must also provide is actually the reasonable time frame. It's a very important to argue that because, for example, in our case, we're explaining to the company that because we are still in the middle of lockdown, the ability of employees to inquire and ask for legal advice is very limited, and therefore the consultation and feedback that they requested from the staff must be extended post-lockdown period. This is actually to make sure that any employees will be able to get a proper advice. Now, what we're also advising to any employees out there, they should also ask for the selection criteria if ever there is a redundancy process. The selection criteria is very important just to make sure that the selection is not predetermined, that the selection will not be prejudiced towards migrant workers, because I still remember in 2008 and 2009, because of that global financial crisis, some employers have decided that those workers with temporary visa would be prioritized for redundancy. That is not fair, and that is not actually lawful. So therefore, you have to check the selection criteria. If ever you see that that's part of the criteria, that could be actually easily challenged under the Employment Relations Act. Okay. Now, we're also asking migrant workers to provide feedback, and they should not be shy about that. So for example, there are migrant workers who actually applied for permanent residency, and some of them are also on work to residence visa. It's very important that they also explain to their employers that if, for example, they've been made redundant, how their application will be affected. Or if the employer decided to reduce their hours of work, meaning from 5 days to 4 days, And some employers are also saying that they actually prefer to reduce their pay rate. They need to explain to those employers the possible impact to their immigration application. And I dealt with them with a few migrants in the last few days. And some of them were actually successful when they explained that by reducing the hours and the pay rate, that will actually jeopardize their permanent residency application. One employer actually totally understand and accepted that. So therefore, the redundancy was delayed. The other one was the employer simply reduced the hours of work but did not reduce the pay rate. So it's very important that we have to be transparent to them by providing those kind of feedback. All right. Now, remember, if the employer is actually changing their individual employment agreement, it must be by mutual agreement. The employer cannot simply or arbitrarily change the employment agreement without the consent of the other party. And I always advise those employees to seek legal advice before they sign the contract. The last one that I would like to discuss is actually the emergency benefit for migrant workers. Because a lot of migrant workers will be affected by redundancy, then afterwards they will be struggling to find jobs and there is no available flight for them to go back to their country of origin. So we have been discussing with Minister Ian Lees Galloway and Minister Carmel Cepoloni that the emergency benefit under Section 64 of the Social Security Act 2018 must be actually granted for temporary visa holders. And if ever they could actually extend that up to 6 months, that will help a lot of migrant workers. Otherwise, they don't have any money to pay for their food, let alone for their rent, especially if there is no available flight for them to go back home. So I think the positive note about that, it's actually under strong consideration. It's being discussed now at the cabinet as well. But however, we believe that it will be part of the bigger announcement on the 14th of May. So we're still hopeful that they will approve that. But I think we have to support that because many migrant workers will be very much affected by this redundancy. So that's it for me, Yasmin. I'm happy to answer a couple of questions from the audience.
So someone's asking us, Charlie's asking us, I signed a casual contract with my company. He applied subsidy for other full-time workers during the lockdown, but he didn't apply it for me. Is that legal? He says, I was working for him every week around 12 hours per week before the lockdown for 7 weeks. Now, if he applies for the subsidy for me, should he pay me the past 4 weeks' wage first, then pay me the rest of the wage week by week? Is that something you can guide us on?
Yeah, there are two elements of that question. One is that, is a casual employee eligible for wage subsidy? The answer to that is yes. In fact, if ever you visit the FAQs of Minister of Social Development, it was very clear there. We keep on sharing that to those employers who refuse to include the casual employees in their wage subsidy application. And many of them started applying for the wage subsidy application. The second one, it's a gray area whether it will be retrospective or it will be actually paid retroactively because it's not included in the guideline. So we're just simply applying the principle that the employer must act in good faith. If ever they can actually back pay those casual employees, they should. Or if ever they can actually simply readjust the 3 months wage subsidy. So for example, if ever for the last 4 weeks, or for example, if ever they missed out the last 3 weeks or 4 weeks, and the employer just granted the wage subsidy for that casual employee by next week, and that's going to be good for 3 months. Now we are now in the hands of the employer whether they would like to move that 4 weeks back in order to cover that 3-month period for that employee. I think that's going to be a conversation that a casual employee must have with the employer. Unfortunately, the guideline is a gray area, but I will argue that the employee should actually be paid that 3 weeks or 4 weeks, and the employer can simply readjust that 3 months time frame and how they should use that wage subsidy. All right. So that's my answer to that one.
Great, thank you, Dennis. So we'll click on finished answering on that one. So let's have a look. I think we also had one up here. There's a lot of interest in wage subsidy, I can see, but we also had one here. I'll bring that one up. Agatha's asked us, I'm working in recruitment and they have informed after the 3 months we might be redundant. Where do we stand because I'm on a work visa?
Look, it's a common question. Agatha, you're not the only one asking that question. So there are a couple of things there. For example, there are employers that they already made up their mind to make those workers redundant. But however, because they were eligible to wage subsidy and they already received the money, so what they did, they simply used that wage subsidy to extend the employment of their workers or employees. So therefore, in order for those employees not to be out of pocket and they can still survive day by day, they simply extended their employment by 3 months. Now, what the government is saying is that you cannot actually make those employees redundant while you're receiving a wage subsidy. So if ever they continue on, they decided to make those employees redundant after 3 months. Unfortunately, it's going to be lawful, and it's going to be justified considering that they did not make those employees redundant. Now, the next question is that what will happen to those employees who've been made redundant? What will happen to their immigration status? I think that's something that Nicola can answer afterwards.
Our second speaker, Nicola Tiffin. So Nicola, as I mentioned earlier, she's immigration partner at Anthony Harper Law Firm. She has over 18 years experience in immigration law and she advises businesses and individuals. She's highly experienced in helping individuals with the immigration process, including helping resolve unusual or difficult immigration problems. So she regularly provides training and seminars to both employers and employees to help support them through the immigration process. So let me bring up Nicola's slides and I'll hand it over to you. Thanks, Nicola.
No problem. Thanks very much, Yasmin. Hello, everyone. I think what we've just heard was really helpful, so thank you very much, Dennis. And I think a lot of what I'm about to talk about has a bit of an overlap, so please feel free to interject if you wish to, Dennis. So the first area I wanted to talk about, which seems to be, I'm getting a lot of queries about it at the moment, is whether if you're on a work visa, and it's specifically for your employment, so an essential skills work visa or a work to residence visa or a post-study visa normally, if you're made redundant, what is your legal position with immigration? So the first thing to be aware of is that if you're made redundant, that doesn't automatically mean that you can be deported straight away. So Immigration New Zealand can't come to your door the next morning and remove you from the country. You've got some rights and some time. So that gives you a little bit of leeway, a little bit of time to think and plan. So if you are made redundant, you, under the Immigration Act 2009, you are considered to be liable for deportation, but you have steps that you can take to try and explain why you shouldn't be deported and why you should not be considered to be liable. So the first thing is that if the employer makes you redundant, they may or may not inform Immigration New Zealand. A lot of employers will, of course. And once that happens, Immigration New Zealand will normally take about, in normal times, about 2 or 3 weeks to get in touch with you. I suspect that will take longer going forward. Whilst that's all running, your visa is still valid. So that means that your partner can still work if they've got an open work visa and your children can still go to school. If Immigration New Zealand do decide to take it, can you hear me? I can see there's some messages saying people can't hear me.
I can
Yeah.
hear you fine, Nicola.
Okay.
Are we
Okay.
getting messages that people are having trouble?
Okay. Yeah, that's great. Okay, lovely. So I just saw them pop up and I thought, oh, I better stop. So as soon as Immigration New Zealand decides to take action, what they can send you is something called a deportation liability notice. So when you get that, you've got 14 days to write back to them and explain why you shouldn't be removed from the country. And you've also got 28 days in which to appeal to the Immigration and Protection Tribunal. So that would be on humanitarian grounds, specifically that it wouldn't be safe for you to return to your home country. So it depends very much on your personal circumstances. Also, there may be other humanitarian circumstances that mean that it would be unjust for you to be deported from New Zealand, such as close family in New Zealand or other humanitarian connections. So at that point, if you get a deportation liability notice, it's really important that you immediately speak to a lawyer and get some practical advice. If you don't have any grounds to appeal and you decide that you will leave, but you need time to leave, it's really a very good idea to let Immigration New Zealand know that and to liaise with them, because then they won't actually won't take any steps to actually remove you. They will give you the time to buy your tickets and exit the country. Now, one really important thing to be aware of is that if you do not appeal within those 28 days and leave New Zealand after the 28-day deadline, you will be deemed to have been deported from New Zealand, even though you weren't really deported, but because you could have been, you'll be deemed to be, and that will prevent you getting a visa to return to New Zealand without getting special permission from the Immigration Minister. So what's really important is if you do get to the position where you're made redundant and you get a deportation liability notice, you do need to get some help from a lawyer or a good immigration advisor who's got experience in dealing with appeals as soon as possible. But my main point that I did want to make is if an employer starts down the redundancy route, do follow Dennis's advice in terms of going through the consultation and seeing if you can get redeployed so you can get your work visa varied, and do seek some employment law advice. It would be, if the employer isn't following any proper process and not acting in good faith. If you can't, if that's not going to work out, because a lot of employers don't have the work anymore, then the next step is to try and find another job. And if you can't, bear in mind that 28-day deadline to either appeal or leave the country. So hopefully that helps, and I'll move on to and just let me know if you have any questions. So next thing I wanted to talk about was reduction in pay. So this is happening right now to a lot of people, and that's employers are taking the wage subsidy and they're wanting to pay their employees normally about 80% of their what's currently said on their employment agreement. So normally they would send you through a letter saying we're proposing to reduce your salary or your hourly rate by 20% for the foreseeable future or for the next 6 months. The issue is that a lot of work visas say that you have to be paid at least $21.25 an hour or $21.68 an hour. And also if you're on a work to residence visa, depending on when you got that visa, you would need to be earning at least $26.50 an hour for 40 hours a week. Or if you got that visa after October last year, you have to earn $38.25 per hour for at least 40 hours a week. So if the employer does this and pushes you into taking a pay cut, then you could be in breach of your visa, and also the employer themselves could be in breach of the Immigration Act because they've incited or counseled you to work in breach of your visa. There might not be much practical help, but it might be worthwhile pointing it out because maybe it will be the difference between getting that pay cut or not. However, it could mean that you end up going down the redundancy route. So again, it's really important to seek employment law advice and consider getting a new job or getting your work visa varied. And hopefully on the 14th of May, as Dennis says, we'll have a few more announcements from Immigration New Zealand about varying work visas, because at the moment they're only allowing variations for people working in essential services and only on a very limited nature. So we do need to be keep an eye on that. If you're on one of those work to residence visas where you need to earn at least $55,000 over the course of the year based on a 40-hour week, it might be that if you have a very temporary dip in earnings and you make it up over the rest of the year, you'll still be compliant. I've been discussing this with Immigration New Zealand, and they've asked their policy team to clarify that. But at this point, I've got some indication that some discretion may be allowed in that case. Okay, so, and I just see a comment in here from Kimberly, which I'll just address. Yes, and that actually moves me quite neatly, I think, into the, not the next slide, but the next final slide, which is work visas being extended until the 25th of September. So yes, if your work visa is going to expire by or before the 9th of July, but after the 1st of April, 1st of April onwards, you will have been giving an automatic extension through to the 25th of September. So that's really good, but just be careful, because if you're on a working holiday maker visa, for example, some working holiday maker visas only allow you to work for 3 months of that visa. So the extension of the visa does not automatically extend the period that you can work. Also, if your work visa is going to expire and you're on an essential skills work visa, your employer is going to have to advertise the position and show that they can't find another New Zealander to do the job or train to do the job. By the 25th of September, it's going to be very hard to do that. So if you can, I would get a new work visa application in sooner rather than later, before the labour market becomes very, very difficult. So I just thought I'd answer that one, Kimberly. So let's go back to the next slide, varying work visa conditions. So there's quite a lot happening in that space at the moment, because Immigration New Zealand and the government are aware that migrant workers are losing their jobs and that many of them cannot leave the country. So they're allowing essential workers to vary their conditions of employment to work at a different job, so different occupation but for the same employer, or to stay in that same occupation but work for a different employer in the same location within New Zealand. And the employer applies to that. There's no charge. And I understand that they are prioritising those requests and they're being done very, very quickly. If you get made redundant and you need to move and you're on an essential skills work visa and the new job and you're working in Christchurch, but the job you've been offered is in Auckland, you're going to need to go through the proper variation of visa conditions process, which costs $190. And the new employer may need to demonstrate that they've been through a labour market check and can't find a New Zealander for the position. So again, you need to act quickly and get those applications underway. In that case, the employer supplementary form is going to be needed as well. So again, if you're looking to stay in New Zealand and you think your employment is going to come to an end, then you need to move quickly and start applying for new jobs as quickly as you can, which is going to be difficult, but it's if you want to stay, you should proceed with that. So the final slide I want to talk about was the skilled migrant category. And I can see a few questions coming up before about that. Yes, there's been an enormous backlog with the skilled migrant category. I have no idea why Immigration New Zealand hasn't kept abreast of the number of applications. But yes, people have been waiting well over a year for those applications to be processed. Not last week, at the end of the week before, just before Easter, Immigration New Zealand quietly announced that it is suspending selections of expressions of interest. So you can submit an expression of interest online under the skilled migrant category, but it will just sit there for the time being. They're not going to be considering inviting anyone else to apply for residence under that category. So that's on hold. I don't know what that means for people who currently submitted applications, but it's likely that once Immigration New Zealand is back up and running, they will be processed in accordance with the law that was in place at the time they were submitted. Luckily, the New Zealand government, when it comes to immigration law, doesn't tend to change things retrospectively. Other countries do, but not New Zealand. So if you've already got your skilled migrant category application in, it will continue to be processed. But if you have been made redundant, then that may impact upon your eligibility to actually be approved, because what will happen is when your application is considered, the immigration officer needs to check that your employment that you've mentioned in your application is sustainable and ongoing. And if you're no longer in that employment, obviously that you won't meet that requirement. So again, if you've got a skilled migrant category application underway and you want it to go through and your job is in jeopardy, then you may need to look for another job. Or possibly if you don't need the points for the job, but most people do. I expect that when the skilled migrant category applications processed again and expressions of interest are being considered, that we may find that the requirements are reset. They may make it more difficult to qualify. So, but we'll just have to see what the announcement is on the 14th of May.
So Agis has asked, I'm a new migrant on dependent work visa, about 7 months now in New Zealand. I'm not employed and our residency application is under process in the final stage with immigration. My partner is in health sector, but I am not successful in getting a job, and now the chances of getting a job is less in the near future. In such situation, will there be any assistance if I get residency but unemployed?
Okay, so normally when you get residence, it's on the understanding that for the first 2 years, you will be ineligible to claim any benefit or financial support. But as Dennis was saying earlier, there is the emergency benefit. And I would imagine that if your partner is unable to support the two of you on his or her income, then you should be able to access that if you meet the criteria for the emergency benefit.
Okay, great, thank you. And Nicola, another one for you here. I'll just bring this one up. So Gangadeep Kaur asks, I am working with the company from 5 years and my visa will expire on the 17th of July 2020. Now they don't want to help me for further visa. What can I do now, she asks.
Okay, so as Dennis was saying before, one of the fundamental requirements of employment law in New Zealand is that an employer has to act in good faith. And just saying they don't want to help you apply for another visa that would arguably be in breach of that requirement. So they need to actually explain why they cannot help apply for a new work visa. And that may be that there's no longer a position available, or that they won't be able to demonstrate that there isn't any New Zealanders available for the role. In which case, if it's the latter, I would suggest that the employer, to actually adhere to their obligation to act in good faith, advertises the position and demonstrates to you that there's not any that there are New Zealanders available to do the work. it very much depends on what you do, and you may be sensible to either think about applying for a new job, or, and as a backup plan, think on the 17th of July your work visa is going to expire. You're not going to get that automatic extension through to September, so you'll have 42 days from the 17th of July to appeal to the Immigration Protection Tribunal against being liable for deportation. And so if you leave after those 42 days, you'd be deemed to be deported. So what would be really important for you is to keep that deadline in mind, and if you can't get another job, then make sure you leave New Zealand before that date, so you can open your doors to come back.
We'll say we've answered that one. Now, before we bring in Dennis, I thought, again, one for you, Nicola. Here, I'll bring it up live now. So Bradley asks, I'm a skilled migrant here in New Zealand for almost 4 years. I have a residency application pending and have been waiting for a decision since 2018 due to INZ prioritisation. If I'm made redundant, what happens to my residency?
Well, I've pretty much talked about this before. If you're made redundant, then when the residence application is being processed, the immigration officer will check that your employment is ongoing and sustainable. So if you're no longer in the employment, then the application is likely to be declined, because you won't have enough points to claim points for skilled employment. So you may need to, I mean, I don't know what your job is, Bradley, but you may need to look to find alternative employment if you're looking at redundancy, or if you can't and you're likely to be made redundant before the residence application is prioritised or processed, then you may want to look at withdrawing the application rather than having a decline.
Paul asks, I'm a part-time employee of Allied Security as security guard. Because of the outbreak of COVID-19, lots of shifts have disappeared. The remaining shifts were given to the full-time employees in priority, so I was given no shifts recently. But at the same time, I have to pay rent and some essential things. I asked the manager of the company and got answer of the following: unless you are medically directed into isolation over 70 or have an immune disease, then you are not entitled.
Yeah. Look, there are a couple of things that I need to understand from that question. When you say you are part-time, are you actually referring to your casual agreement, or you are a permanent part-time employee of Allied Security? Because I think we have to establish it first. If the situation is the latter, meaning you are permanent part-time, then it means that you have guaranteed hours, and therefore the employer is obliged actually to pay you accordingly, and therefore you cannot simply lose that shift and give it to someone else. The employer actually must comply with your individual employment agreement. Now, if ever it was a former, meaning you're a casual employee, then there could be some concerns there and issues that will be hard for us to establish because of being a casual employee. The response of the employer actually doesn't make sense, because I don't know if have you asked for essential leave and the employer actually refused to grant your request, or you're saying that you must be paid while working or while staying from home? I think because I don't understand, it doesn't make sense why the employer responded using that quote unquote.
And let me have a look here. I have another one for you, Dennis. Let me bring this one up. Okay, so Juliana asks, I was working for a hostel here in Queenstown. My employer applied for the subsidy for me and then made my role redundant the same day of the starting of the lockdown. I reported him to the MSD and he was requested to return the money. I didn't receive any money for subsidy. I don't have a job and no opportunity to find another job as my visa depends on them, and now it's hard to find another sponsorship. What can I do? And maybe Nicola, if this is one you'd like to join in on, please join us.
Yeah, look, this is actually the problem of the guidelines on wage subsidy, because we have to remember the wage subsidy is being given to the employer. And there is a clamor out there that if the employer is not really actually keen to apply for wage subsidy, even though they're eligible, then there should be another step where an employee can be the one actually apply for wage subsidy. Unfortunately, this is one of the things that there's a question mark. We don't know what the answer is, because obviously, if ever you've been made redundant and the employer actually got the wage subsidy, they're actually breaching the guidelines of the government. Now after that, if ever there is no way the person can avail the wage subsidy, I think unfortunately there is no straight answer how we can actually support the person unless the government announced that we are not granting the emergency benefit for migrant workers or anyone who's actually displaced because of the current pandemic.
So, Nicola, can I bring you back in for a question now that we've received?
Yep.
So I'll just bring that up onto the screen now. So Assad says, I've got married 3 months ago in my country, Iran, but due to COVID-19, all immigration offices have been closed and was not able to apply for a visa for my wife. He says, when can I apply for partnership visa or culturally marriage visa?
Okay, assuming, congratulations on the wedding, it's lovely. Assuming if he or she is a New Zealand, he's a New Zealand resident or citizen, then yes, you can apply online for permission to apply for a visa. There's that link through the Immigration New Zealand website, so you can bring your partner, as being a partner of a New Zealand citizen or resident to New Zealand, and you'll need the online form's doesn't give you a lot of room to write in, so I think you need to make it very clear that how long you've been in a relationship for, and that you got married in Iran but you couldn't bring her back with you because of the closure of the offices. So I'd apply for that permission, and then the application should actually be able to be processed, because you make the application online and it should then be processed via one of the New Zealand offices. The only tricky bit will be getting the medicals and police certificates that you need. But hopefully things, I don't know quite what the situation is in Iran, but hopefully I know even at the best of times it's difficult to get the INZ medicals done there. So it'll depend on when you can get those done, whether you can submit an application. But in the meantime, get permission to submit that application by applying online.
And Dennis, one for you again. I'll just bring this one up onto our screens. So Jasmine says, my husband is an engineer. One day after lockdown, my husband received an email from his employer informing him that he will be moved to a part-time job due to not too many projects during lockdown. Then they pay him or his wage the same amount of the wage subsidy. Is his employer doing the right thing as no warning or heads up before the lockdown?
Look, there is, looking at the information in front of me, and this is my opinion, there is a case here for unjustified disadvantage, because the employer actually failed to act in good faith by having a genuine consultation with the employee concerned. I think this was just a decision made by the employer. And look, there are many employers using the lockdown to arbitrarily change the individual employment agreement, and these employers are exposing themselves for future litigation. So I think my suggestion is actually for your husband to contact an employment lawyer after that, because there is an arguable case that you can file for unjustified disadvantage, because what happened here was there was no genuine consultation, which is actually a breach of good faith provision of the Employment Relations Act.
One for you while you're there. I'll just bring this one up now. Nirashini asks, if someone is paid a wage subsidy by an employer for a temporary casual employment for his part-time employment of 20 hours, does that casual employer work in an essential service to earn something more to cover up the expenses of his family if other members of the family are not earning?
All right. So my understanding, if ever the person is actually working 20 hours, that's my understanding from the question. So my understanding is that the person should be receiving at least 585. So if the employee is actually currently working, for example, in a hospitality business and can earn more than the 585, I argued this many times that the employee concerned should be receiving more than 585, not simply passing on the 585, because passing on the 585 is simply for those who are in lockdown and they are not actually working. But my understanding in this question is that they are an essential business, although the company is actually suffering 30% decline on their income. But if ever the person is actually working more than those required hours or more than the 585, they should be getting actually more than that.
Okay, we've got more questions coming in. This is really great. For you, Nicola, I'll bring this one up. Hold on a second. Here we go. So this is from Teresa. She says, I have essential skills work visa and have applied for partnership residency, which you should know the result in October 2020, but there is a pretty big chance of my redundancy. We wanted to get married this year and I could theoretically work for my fiance husband's company if redundant at the current position was, but not sure how INZ will look at that because of course he will not hire anyone when he knows I can do that job for his company.
Hi, Teresa. I think you're in a reasonably good position. You need to apply for a partnership-based work visa as quickly as you can, and that application should be given priority. So a partnership-based work visa will allow you to work for any employer, and you can also be self-employed if you wanted to. You could even work as a contractor. So I would do that as soon as you can. You can do it online, and a lot of the documents that you would have submitted for your residence application, you'll be able to reuse for your work visa application. So I'd get that in. And hopefully that will be processed within a few weeks before you get before the redundancy happens, and so you can go and start working with your husband, fiance husband.
One for you as well while you're there. I'll bring this one up. This one's from Kimberly. For someone who holds a resident visa but is not permanent resident, if the person leaves the country while the current border controls are in place, would they be allowed to return to New Zealand?
Yes.
That's a yes. That's great. Yeah. Okay, and let me have a look. I did see one here for you, Dennis, from Eleanor. I'll just bring it up now. Here it is. And she says, for Dennis, can you remind us the cap again for level 3 wage subsidy for 3 months?
No. Just to be clear, the wage subsidy given by the government, it doesn't have to be level 4, level 3. That's actually the wage subsidy that they announce before the lockdown period. So meaning they will be using that for 3 months. So for example, in 3 months' time, whether we are in level 2, the point is that the company must use that for 3 months' time period.
Find that, Dennis. Now let me I'm just having a quick look at our, okay, Nicola, if we can ask you this one, I'll just bring it up now. I'm with skilled migrant work visa and residency is deferred for 1 year. Now 9 months gone by, will they extend it?
So I'm guessing, Rasika, that you mean that you've you've applied for an essential skills. You have an essential skills work visa, and you've applied for residence under the skilled migrant category, and it's taken 9 months already to process. And will it take longer? Very probably it will take longer, because almost no immigration officers are working at the moment, and they're already behind. So I think it will take longer. Yeah, so I think that's the answer to that question. I hope so. If it's not, just let me know.
And another one here from Carolina. I'll bring that one up as well for you. So Carolina asks, what about the people who are waiting for the residency visa?
Yeah, that's basically the same thing. I think the waiting times are going to continue to grow, because we've had at least a month without immigration officers doing any work, and applications are already taking well over a year. I suspect that they will prioritise people in the healthcare sector and the essential services, but everyone else is going to have to wait, which is concerning, considering a lot of people are losing their jobs, which will mean that their residence applications will not go through.
Great. We've got a few more questions in here, so we'll just click. We've finished with that one. So Dennis, there's one here, and I think in some of these, well, this is Bradley again, actually. Let me bring this one up. What's happened there? Oh, sorry. I'm not sure if I can bring that one up, but I'll say it. I'll let you know what it is, Dennis. My company is making people redundant after 4 weeks of lockdown, even though they have received wage subsidies for 12 weeks. Is this legal? Look, I think this is one you covered off a bit earlier, but if you could just run us through.
Yeah, I think there are two things here. If the company received a wage subsidy because they're eligible to that, then if ever they decided to make those employees redundant, then the company is under obligation to return the money to the government. Okay, that's one. But if the company decided to go ahead with the redundancy and decided to keep the money, then they expose themselves for investigation and possible penalty from the government.
Thanks for that, Dennis. Let me have a look. Just looking at our questions again here. I'm just checking. I'm wondering, have we had this one? Let me just have a quick look. Okay, I'll bring this one up. Sorry if we've seen it already, but Juliana says, my essential skills work visa was going to expire on May 20th, and it was extended until the 25th of September. However, I was made redundant the same day of starting of when lockdown started. I haven't been able to get a new job as nobody is in a position of giving sponsorship. I cannot do a variation of agreement as my position is receptionist cleaner in a hostel, and all the accommodation services are closed and might continue to be closed after we move to level 3. What can I do?
Okay. Well, the great thing is that you've got this visa that's running through till September, and unless Immigration New Zealand start the deportation process, i.e. send the deportation liability notice, your visa is still valid and you are able to stay in New Zealand. So you can stay through till the 25th of September as long as Immigration New Zealand don't start the deportation process. So you've got that time to try and find another job. And hopefully as we come out of Alert Level 3 and then move into Alert Level 2, it'll be easier for you to do so. And then you can apply for the variation.
Excellent. Thank you, Nicola. And one in here for you, Dennis. I'll bring this one up. This is from Joel. His question is about qualified or not to get the subsidy. What will I do when the company has not applied for the wage subsidy? I cannot force them to do it. Can I apply myself online, and how?
Yeah, unfortunately, Joel, that's going to be a complicated case. One is that the company must be eligible to apply for wage subsidy. So therefore, they have to meet the requirements, like, for example, the 30% decline of their income. Now, if the company is eligible and did not apply, and therefore to that effect you were disadvantaged, what will happen as a remedy for you is that you can actually file a personal grievance for unjustified disadvantage, and employers will be actually exposing them for future litigation because of that.
And another one for you here, Dennis. So we've got time for probably just a few more questions. Okay, so I'll bring this one up. So can the employees get wage subsidy until 12 weeks, even if the lockdown may not remain until 12 weeks?
Yeah, look, the wage subsidy is not simply for lockdown. It's actually to assist employers who are now affected by the pandemic outbreak. It's actually to assist the businesses in order to recover from the lockdown period and from any effect of the outbreak. Because it's not only the lockdown, meaning some employers will not be able to trade overseas. They will not be able to get supplies or export their products. So that's the reason why the government announced the 12 weeks subsidy for employers.
Thank you. And one now for Nicola. So I'll bring that up now. And then there's also a second part to this question. So Ravi has said, for talent resident visa, for those working 37.5 hours, earning more than $51 an hour, but not 106,500, are they eligible for faster processing priority queue? And then Ravi came back to clarify 106.5K annually, since it's not 40 but 37.5 hours. Does that make sense for you?
Okay, yeah. So there's two issues there. It sounds like you're still going to comply with the requirements for residents, but also earning over 106.5K, that is the cutoff for people to be given priority for the residence application. So yes, it should be given priority.
I'll bring up another one for you, Nicola. We're working our guests hard today with all these great questions. Currently, I am interim visitor visa, and due to COVID-19, my application has not changed from 2 months. I'm going to apply for, is that post-study work visa, but it's taken time. I'm applying for a job in essential services, but they need my work visa. Can I approach Immigration New Zealand and ask for speeding up my visa process? And if yes, how and where?
Okay, yes, you can, and I think, but you'll need to provide evidence that you're going to go and work for one of the, well, that you've got a potential opportunity to go and work for one of these essential services. So a great idea would be an email from a potential employer, and then yes, you can. There's a certain email address that lawyers can write to who can request escalation of an application. So it's best to reach out to an immigration advisor or a lawyer to get that escalation done, or you can call the helpline yourself and request it. But it should be a really easy job for an immigration advisor or lawyer to do and not charge you very much money to do that. It should be a half-hour job.
Thank you. And another one here, Nicola, and then I think we'll have one or two last questions for Dennis. So I'll just bring this one up. It says, hey, Nicola, from ANKIT, what is the total time after the redundancy I can stay in New Zealand and look for a new job?
It depends. It depends on, the starting point is how long is your visa valid for. So as long as if your visa is valid and Immigration New Zealand don't take any steps to deport you, which I think that they're unlikely to do so for quite some time, then you can stay here for that, and then plus 42 days before your appeal rights and the situation becomes much worse. So to answer it much more succinctly, usually up to the expiry date of your visa plus 42 days.
Okay, great. Thank you for that. Now, I think this next one is one for Dennis. Let me bring it up. It says, Is there going to be any changes to the requirement for the, is this expression of interest applications after the 14th of May? Is this for Dennis or Nicola? I'm not quite sure.
Can I just clarify the 14th of May? The 14th of May is actually the budget announcement of the government.
We're also expecting Immigration New Zealand to make several announcements around the same time. Yes, there's nothing has been said, there's nothing been published or announced, but I would expect that there will be some changes to the requirements for the skilled migrant category. It may not be on the 14th of May, it could be earlier, it could be later, but I expect that there will be changes because the skilled migrant category is supposed to be set to allow for supplementing the New Zealand workforce, and so if we don't need any supplementation of the workforce, then they're probably going to make it quite difficult to qualify, to keep the numbers down.
That, and just I think we've worked through our questions from the audience, so thank you for that. I think my last question to both of you would be, you know, just from your perspectives in your roles and the work you do, how are things, how's this going to play out in the future? Because I know we really do need, migrant workers are so essential to the rebuilding of New Zealand and New Zealand's economy. So what's the future holding for us?
Well, from an immigration perspective, it's very difficult. I mean, I've been an immigration lawyer for close to 20 years, and and I'm sure Dennis has never seen anything like this either. I expect that at the moment the general political feeling is that the borders should be closed, and we're going to be battling against that for quite some time. I'm hopeful that what will happen is that we'll allow people who are already here to stay, and that arrangements will be made to allow them to progress to some more flexible visas. But I expect it could be a couple of years before we get back to more movement internationally, at least. It will depend very much on what happens with the vaccine and the approach the government decides to take in terms of managing the risk created by the virus.
Yeah, my view is that because I've been discussing the economy with some of our experts, even from the government, and their estimate is that it would take around 2 to 3 years before our economy actually can recover from the effect of this pandemic outbreak. However, I think this is the opportunity for New Zealand to diversify its economy, because it also exposed New Zealand now to different kinds of problems. For example, the supply chain is actually affected by the pandemic outbreak. So I think a lot of businesses are now looking in that area, and this could be part of the just transition discussion and future of work for New Zealand.
Would be, you know, people have had a lot of questions today, and they'll continue to have questions around their own situation. So where, just briefly, you know, where would you suggest that people go for further help?
Look, for employment, the Council of Trade Union put up a website under the Together banner. So they are collecting about complaints concerning wage subsidy, annual leave, etc., etc. And the government also put up a website if ever they have concerns about employers breaching the wage subsidy. They can directly go to the Ministry of Social Development website. And according to the Labor Inspectorate, because they're working with the MSD, they have now received almost 2,000 complaints, if ever I recall that correctly. That's soon to be investigated once they're allowed to operate, probably in level 2.
And from an immigration perspective, at this point in time, I think it is important that people who are facing redundancy and are on visas do get some initial advice from an immigration advisor or a lawyer. So they're quite clear about what their situation is. As it might be possible for as things change, for the lawyer to come in and help them get the new visa or vary the visa. So just stay in contact with lawyers and also I think, just following on from what Dennis was saying, in getting employment law advice is very important as well.
Thank you both to Dennis and Nicola. That's been brilliant having you here to give us your perspectives and share some of your knowledge around, common concerns, and then answer some questions right here with us from the audience. So I really thank you for your time today. That's all